Sex discrimination can appear in different ways. And we look at these as different types of the same discrimination. One of these we call sex plus discrimination. And by sex plus, we mean that discrimination is made on the basis of placing additional requirements on employees of a certain sex. So an employer may hire, say, for instance, may hire women in general, but not hire women that have certain other factors. The case on this is known as, or the best case on this is Phillips versus Martin Marietta. Martin Marietta, and this is a case that went all the way to the Supreme Court. Martin Marietta is a defense contractor, and it had a policy against hiring women who had children, preschool-age children. The basis of the policy was that if those children get sick, which is something that preschool-age children do routinely, then it's more likely than not that it's going to be the mother who's going to stay home with the kids. And therefore, a mother of preschool-age children is much more likely to miss work than a father of preschool-age children. And so they had this policy that prevented the hiring of women with young children. Well, obviously, Ms. Phillips says, look, I'm being treated differently. I'm being treated differently solely because I am a woman. And this case, again, goes all the way to the Supreme Court, and the Supreme Court agrees with the plaintiff in saying that you have to have a neutral policy. Now, they could have had a policy that says we don't hire anyone with preschool-age children, and that would have been okay because we're treating them equally. But the fact that men with preschool-age children could work for the company while women couldn't, that was sex discrimination. Another issue that often comes up in employment has to do with grooming codes, workplace grooming codes. What are the dress codes that and how they relate to sex stereotyping? Now, know this, that courts give to employers a great deal of leeway in determining dress code. The belief is that for many corporations, their public face is that of their employees. That for customers, their concept of who the employer is going to be based on the employee. And therefore, courts have traditionally given employers a lot of leeway, meaning they can have different standards for men than for women without running afoul of the anti-discrimination laws. For instance, a case involving Blockbuster. If you remember Blockbuster, the old video store, 4 male employees of Blockbuster who all had long hair brought a lawsuit. Blockbuster had a policy that men had to have hair that was shorter, that did not reach the shoulders. They did not have an equivalent, any sort of policy on hair for women. And therefore, the male employees said this is sex discrimination. We are being treated differently than women. We are not allowed to wear our hair long, but women can. Well, the court sided with the employer, saying that an employer can make these sex-based differences in their grooming codes. So on your test, it's quite likely that if it's a grooming code question, the court will side with the employer. Not every difference in dress code, even those that are based solely upon sex, is illegal. There's another relatively recent case involving a woman who worked for a casino in Reno, Nevada, Miss Jesperson. And she was a bartender there. And the casino had rules for how its bartenders dressed. Now, the men's rules were pretty open-ended. Basically, you had to be clean-shaven and you had to look presentable. You had to be presentable looking. Women, however, had a very specific set of instructions on how to dress and how to apply makeup. Everyone was required to wear makeup. Makeup being defined as blush, powder, mascara, lipstick, and all of those had to be present. That they had to have their nails polished, but they could only use red, clear, or pink colors. They were limited to those 3 colors. And so it was a very different dress standard than that of men. And so Ms. Jesperson brought a lawsuit. This is illegal sex discrimination. Oh, women were required to wear high heels. Women were required to wear hose. Ms. Jesperson says, I don't like high heels. I don't like to wear hose. I don't like to wear dresses. Therefore, I'm being treated differently than men. I don't wear makeup. Well, this case again goes to the appellate court, and this is the Ninth Circuit in California, which is traditionally thought of as a very liberal court. Nevertheless, the court sided with the employer, saying, look, employees are the face of the company, and therefore the employer has the ability to dictate how those employees should look. Another issue that comes up has to do with customer or employee preferences, coworker preferences involving sex discrimination. And the fact is, Title VII doesn't permit the employer to consider customer or coworker preferences. You cannot argue that customers won't accept a man in that job just because they don't like men in that position. You can't argue that coworkers won't accept a woman in that job just because they don't want to work with a woman, and vice versa. So Title VII doesn't allow an employer to take those kind of things into account. The Civil Rights Act of 1991 also extended Title VII to U.S. citizens employed by American companies outside of the United States, which oftentimes those countries have a very different standard when it comes to proper roles for men or women. And nevertheless, the Title VII reaches even those employees. So if you are a woman working for a company that does business in the Middle East, that company cannot take into account the preferences of their customers, even if they are in a society where traditionally women in the workplace have not existed or not been granted equality. Sexual orientation discrimination is an area that we've seen a lot of change in recent years. And what the EEOC has maintained for the last few years is that sexual orientation discrimination is sex discrimination. Now, if you'd asked me, 10 years ago, 5 years ago, can I bring a Title VII claim based on sexual orientation? I would say no. It may not, it may be the right thing. It may be bad that you were discriminated against on the basis of sexual orientation, but historically the categories were race, color, sex, national origin, religion, and that if Congress wanted to include sexual orientation, they had the ability to do so, but had chosen not to. A number of states do have protections, explicit protections based on sexual orientation. Nevertheless, the EEOC, and now we've had 2 federal courts of appeal that have sided with the same thing that says that discrimination on the basis of sexual orientation is sex discrimination. Why? Because it's based on sex, that one cannot take into account sexual orientation without starting with the notion of sex. And that if I have a female employee who marries a female and I fire her on the basis of that of sexual orientation, but I have a man who could marry the same female and would experience no employment issue, well, that's sex discrimination. So because we cannot look at sexual orientation without reference to sex, then it is included within the umbrella of sex discrimination. So in the past years, we've seen several federal circuit courts adopt this position. In many parts of the country, you still can't bring a claim for sexual orientation. You can bring a claim oftentimes on the basis of sex stereotyping, that if a man in the job is treated differently than a woman in the job because of sexual orientation, you could bring a sex stereotyping claim. But now we're seeing a movement, and I think in the future this is going to be the standard, is that sexual orientation discrimination is sex discrimination. So there are 3 reasons for this, and the first is that sexual orientation discrimination necessarily involves treating workers less favorably because of their sex. I'm firing the woman who married a woman, but I am keeping the man who married a woman. It is also based on the idea of sex stereotyping, that sexual orientation discrimination is rooted in the notion of you are not complying with our perception of how people of a certain sex should behave. The third reason has to do with association. Title VII protects your ability to associate with those that you want to associate with. So even if you are white, but you associate with blacks, if your employer punishes you for that, if the employer fires you or takes some adverse job action, you can bring a racial discrimination claim despite being in the same protected class because of the prohibition on discrimination based on association.